Welcome to KPMG's 10 Minutes of Tax, where we take a deep dive into topical tax issues in 10 minutes. Today, we discuss the company law implications of Brexit in the context of Irish corporate groups with UK parent companies. My name is Salvador Nash, and I'm head of KPMG Legal Company Secretarial, which forms part of KPMG's tax and legal services. I'm joined today by Ciara O'Donoghue, a colleague of mine in Legal Company Secretarial, and also by Emer McGrath, who is an Associate Director in KPMG's Professional Practice Department, specialising in the area of company law and financial statements. Brexit and the EEA. So Ciara, tell me about the EEA and what's the UK's view of it post-Brexit?
Yeah, thanks, Al. So the European Economic Area, or the EEA, was established to extend the EU internal market to 3 countries, so Norway, Iceland and Liechtenstein. Following Brexit then, the UK ceased to be a member of the EEA, and during the transition period, as we know, it continued to be treated as an EU member state. As we also know, though, since the 31st of December last, the UK is a third country when it comes to the EEA, and that position hasn't been changed by the agreement that was reached last December between the UK and the EU. So the question then is, will that arrangement change? And the view of the UK political establishment is that an agreement between the UK and the EEA would present considerable legal and maybe practical difficulties, and it might also disappoint a lot of people who would originally have voted for Brexit. So we think at this moment in time, it's unlikely that there would be any new agreement reached between the UK and the EEA.
Okay, and so to sum up then, Ciara, as I think it's key to our discussion today, the UK are no longer part of the EEA, and it looks like they have no intention of rejoining.
Yeah, that seems to be the case at the moment anyway, Sal, yeah.
Great. And Emer, to put all this into context, what financial years are affected by the UK leaving the EEA?
Well, unfortunately, Sal, it impacts on 31 December 2020 year ends and any financial years ending after that date. And the reason for this, would you believe, is actually because of the timing difference with Brussels. So the transition period ended at 11 p.m. on the 31st of December. And because of this, the effect of the UK leaving the EEA does impact on 31 December 2020 year ends and any financial years ending thereafter. I suppose an example of how this might impact on companies with 31 December 2020 year end, Sal, is in relation to claiming the higher parent consolidation exemption. Under Irish law, there are 2 consolidation exemptions dealing with relying on a higher parent. One is where the parent is an EEA parent, and the other is where the parent is non-EEA. So companies with 31 December 2020 year ends who are relying on a UK higher parent for the consolidation exemption will have to move to the non-EEA parent exemption.
Thanks, Emer. So because of Brexit, an Irish subsidiary relying on a UK parent to avail of the consolidation exemption will now be doing so under the non-EEA parent exemption instead of the EEA parent exemption. So while that's a bit of a mouthful, the good news is that it can still claim the exemption.
Yes, that's exactly it, Sal. It's just going to be captured under a different section of the law.
Great. Back to you, Ciara. So talk about the implications for an Irish company with a UK parent, and what are the key things to look out for?
Yeah, so there's 2 key things, I think, Sal. The first issue is that every Irish company must have at least 1 EEA resident director. So for any company that has been relying on a UK resident director to meet that obligation, they have 3 options available to them. Firstly, they can obviously appoint an EEA resident director. Secondly, they can obtain a bond up to the value of €25,000, and that would pay out on any fines or penalties that might arise under Irish tax or company law. And that bond is valid for a 2-year period. Thirdly, then, a company could obtain a statement from Irish Revenue that the company has an economic link in Ireland. And once a company has that statement, along with a certificate from the Irish Registrar of Companies, they would no longer be required to have an EEA resident director. I mentioned there was 2 main issues. So the second main issue, it relates to Irish companies who avail of a filing exemption in relation to their individual entity accounts. So if that Irish company meets a number of conditions, it could file its consolidated EEA parent accounts with the Irish Companies Office. And that has proved to be a useful filing exemption for groups who might not want to have certain commercially sensitive information available on public record. Of course, that filing exemption will no longer be available if an Irish company was relying on a UK parent. So it might be necessary in that case to look elsewhere in the group for another EEA parent who could, whose consolidated accounts could be filed, or perhaps if the company is a small company, it could look at preparing and filing abridged accounts with the Irish Companies Office.
Okay, that's great, Ciara. Thank you. Some accounts filing issues to consider because of Brexit. Back to you, Emer. We've talked about some of the issues, but there may be some hidden benefits. Tell us about those.
Yes, Sal, I suppose there may be some benefits for certain Irish companies, but it is worth noting that really only a limited cohort of companies are likely to benefit. And that cohort is Irish companies that have a listing only on a UK regulated market. So where that's the case, there are certain exemptions available, as those companies will no longer have a listing on a regulated market in an EU member state. I suppose to put it into context, one of the most notable of those exemptions relates to the requirement to provide a non-financial and diversity statement, assuming, of course, that the company isn't otherwise captured as an ineligible entity under the law. And as well as that, Sal, an Irish company with a listing only on a UK regulated market will also fall out of the specific requirements in the shareholders' rights regulations to disclose the company's remuneration policy and a remuneration report, as they'll no longer be classified as a traded PLC. Of course, we need to be mindful there that such companies will still need to comply with the UK Corporate Governance Code, so the advantages mightn't be too significant there.
Okay, and Emer, is there an issue around UK individuals signing Irish audit reports?
Yes, well, as it currently stands, UK responsible individuals that aren't on the Irish Statutory Auditor Register can't sign Irish audit reports. However, the FRC and IASA jointly provided reassurance that individuals and firms could seek registration in both jurisdictions. So for UK responsible individuals that are currently not on the Irish Statutory Auditor Register, they can seek registration. And if they do so, then Sal, they'll be able to sign Irish audit reports once they're registered.
That's interesting, Emer, in that UK auditors, if not already registered, will need to register in Ireland if they want to continue to sign Irish audit reports. So that's something to watch out for.
Yes, that's correct, Sal, yes.
Great. And to wrap up then, one open question to each of you. Anything else our audience should be aware of today?
Yes, Sal, I would say there are some other considerations to bear in mind for external companies. So taking, for example, a UK company that might have registered an Irish branch, that will now be categorised as a branch of a non-EEA company. Now, there isn't anything that the UK company needs to do in relation to that registration, but there might be some additional information to be disclosed on Companies Office filings from now on. And similarly then, if you take the example of an Irish company that might have registered a UK branch with the UK Companies House, again, there will be more information that will need to be disclosed on filings with the UK Companies House. So take, for example, the Irish company's purpose, or maybe the Irish company's issued share capital will all now have to be disclosed.
Thanks, Ciara. And Emer, any final points?
Well, I suppose there's a few other impacted provisions that are worth to mention here today, Sal. There's a couple of provisions in the law with 5-year restrictions, such as where a company can change from IFRS to UK GAAP only once every 5 years, unless there's a relevant change in circumstance. And there's also the restriction on Irish companies from changing their financial year-end date to once in every 5 years. Depending, of course, on the particular facts and circumstances involved, some companies may be impacted by the requirements of these provisions, as they'll no longer be reliant on the concepts of EEA or EU regulated market, of which the UK, of course, is no longer a part. And possibly one final point I think that might be worth mentioning, Sal, is that there's an existing legal framework for cross-border mergers between 2 or more limited liability companies within the EEA. This would have previously enabled mergers between Irish and UK companies through a prescribed High Court procedure. Unfortunately, cross-border mergers under this legal framework involving a UK company are no longer possible, as this only applies to mergers of EEA-registered companies. And just maybe to reiterate once again, Sal, before I wrap up, that the impacts we have discussed here today are effective for 31 December 2020 year ends and any financial years ending after that.
Thanks for highlighting that point, Emer, as a lot of companies are now preparing their 31 December 2020 financial statements and may be affected by these changes. That concludes our discussion today. My key takeaways include Ciara bringing our attention to the possibility that if Irish companies have been relying on the fact that the UK was a member of the EEA, then they have probably breached Irish company law or have a corporate structure that is not ideal. Emer highlighted the accounting implications and the impact on 31 December 2020 year ends and any financial years ending after that date. And finally, if an Irish subsidiary of a UK company has been relying on a guarantee to avoid filing its own financial statements, then later this year it is faced with the prospect of filing its 2020 financial statements on public file, possibly for the first time. Thanks to Ciara and Emer for their thoughts today. I hope you found it informative, and please visit the kpmg.ie tax and legal webpage for regular updates, and feel free to contact us to discuss any issues you may have. Thanks for watching.